Okay. Is Attorney Del Campo with us?
Yes, Your Honor.
Okay. All right. I know we have a couple of people who can't make it today, but why don't you call the roll and we'll get the attendance going.
Okay. Your Honor is here. Judge Armada.
Present.
Judge Chaplin.
Present.
Judge Green.
Present.
Judge Maturowski. Judge McLaughlin. Judge Pearson.
Present.
Judge Prats. Judge Stewart.
Here.
Thank you.
Okay. So good to see everyone. And just for people who are listening, when we get to an item, if you are here on that, I will ask you to engage your camera at that point in time. And if you are not speaking, just to keep a clean audio feed, please mute yourself if you're not speaking during the meeting. The first item on our agenda is the approval of the minutes from the January 22nd, 2024 meeting. Is there a motion to approve?
So moved.
It's been moved. Is there a second?
I'll take the second.
All right, it's been moved and seconded. Are there any changes or additions to the minutes as drafted? Attorney Del Campo, anything from your perspective?
No, Your Honor.
Anything from members of the committee? If not, all in favor, please raise your hand. Opposed? I didn't see Judge Chaplin's hand.
I wasn't present, so I was going to abstain.
That's fine. All right, you want to abstain. Very good. I appreciate that. Okay, that passes 1, 2, 3, 4, 5, 0, 1. The next item on the agenda is 2023-002, a proposal to amend MCLE rule section 2-27A. I won't read the rest of it because you have it on your agenda in front of us. Attorney Del Campo, could you bring us up to speed?
Yes, Your Honor. This was last on the agenda, September 2023. At that time, you had asked Attorney Weiner to, you tabled it till the February meeting, and Attorney Weiner was going to provide the committee with different dates that they could, if they wished, attend or judge these various mock trial events. He has done that over the several months, and I believe he is here, and also Attorney Rowe from the statewide bar counsel's office is here to address it. I believe also Attorney Uri is in attendance today to speak of it.
Thank you. Is an Attorney Uri is, I don't have enough room on my screen. I don't know if he's available either.
Your Honor, I'm here, and so is Judge Facetta, who's the co-chair of the MCLE Commission.
Great, thank you very much. Why don't I, since the proponent, Attorney Weiner, is with us, why don't I ask him to bring us up to speed?
Sure. Thank you, Justice McDonald. Good afternoon, Your Honors. Thank you for having me here today to discuss the CBA's proposal to amend Practice Book Section 227A. B7 to allow attorneys to receive 2 hours of MCLE credit for coaching or judging certain high school or undergraduate mock trials. In addition to law school mock trials, as Attorney Del Campo pointed out, this has been tabled since the Rules Committee's September meeting. As I'm sure many of you may remember, this proposal underwent a fair number of revisions, which are outlined in tab F of the materials, to address concerns stated by the MCLE Commission with respect to its consistency with the content requirement of the MCLE rule. By quick summary, these changes required sanction of the qualifying high school or undergraduate mock trials by a court, bar association, or approved law school. Emphasize that the attorney involved be required to consider and apply substantive legal principles, including the rules of evidence, and to provide a critique of performance. And clarified that of the 4 hours currently available for judging a mock trial, only 2 may be earned at the high school or undergraduate level. Our view is that the revisions have resulted in a better proposed rule that assures the qualifying mock trials an excellent learning opportunity for both the participating students and the volunteer attorneys. We were very happy to make those changes. And while very gracious and complimentary of the program, the MCLE Commission unfortunately has not voted to support the revised proposal out of continuing concerns about whether the mock trials are sufficient to comply with the first of the three-pronged content requirement, which is that it has to be an activity that, quote, has significant intellectual or practical content designed to increase or maintain the attorney's professional competence and skills as an attorney. CBA, of course, continues to take a position that the mock trial program that we co-sponsor satisfies the content requirement, especially because we use rules that are modeled on the federal rules of evidence, and each year use a fairly complex fact pattern tailored to contemporary legal issues. With at least 3 months to prepare, most with the aid of volunteer attorney coaches, our competitors come equipped to engage with the judges on legal and factual issues, and there's a lot of teaching moments throughout the trials, even for the inexperienced teams. Our volunteer judges are actively engaged, with presiding responsibilities rotated so that nobody just sits back to watch. And finally, our volunteer judges are asked to provide comprehensive written and oral feedback. Our view is that an award of MCLE credit would be consistent with the nature of the tasks that the lawyers are performing while judging the trials, and wouldn't just be a token of appreciation for community service. So now with the CBA and the MCLE Commission had a disagreement on this critical point, last September, we jointly requested that the Rules Committee table the matter until this meeting to provide its members with an opportunity to join us for the regional and statewide trials, and also to get their own independent impression of whether judging or coaching high school mock trials is an exercise that provides attorneys with sufficient practical or intellectual benefit to warrant MCLE credit. We were very happy to welcome 2 members of the committee, Judges Armada and McLaughlin, to join us both in New Britain and Bridgeport. At this point, we have 2 high school mock trial opportunities left for this year. One is our second playoff day to be held in Middletown on Friday, March 8th, and the other potentially is a championship round to be held before the Supreme Court on Wednesday, March 20th. Should the Rules Committee like one more opportunity to judge or visit, we're happy to invite you to table this matter for 1 more month until the March meeting. And of course, I'm happy to take any questions that the committee may have.
Thank you. Let me first ask Attorney Sullivan to turn off your camera at this point. I don't think you're here for this item. So, I think we have Attorney Rowe, Attorney Uri, and Judge Faceto. I don't know who wants to talk first.
Attorney Rowe.
Attorney Rowe. You're mute.
Sorry. The commission did meet in September. They have not changed their position at this time. They were willing to continue to have conversations with the CBA about this matter. I know I will be participating on March 8th in the mock trial. I believe Attorney Weiner had indicated there may be another judge from the MCLE Commission who is participating. At no time did we mean to demean the program or make it appear that it wasn't a worthwhile endeavor, but we just have a substantive disagreement about the matter. So the commission could meet again, but I know you're getting close to the end of the calendar for the Rules Committee in terms of how many more substantive meetings you have.
Attorney Uri?
I would agree with Attorney Rowe's comment, Your Honor. I looked at the materials. We're not being critical in any way of what Mr. Attorney Weiner's done. I mean, it's a terrific job, but the fact of the matter is there's just a disagreement as to whether we should be awarding MCLE credit at the high school level, and the commission members unanimously felt that we just shouldn't. And part of the problem is that, we don't have an MCLE, sort of staff. This is all done primarily on everybody's word, and that was the way we set it up. There wasn't any money for that, so there was sort of an idea of just having the line where we've got it, which is at the law school level as far as moot court goes, and that's what we wrote in our letter that was submitted to the commission. But if the commission and Rules Committee wants to table it 1 more month, which is Attorney Weiner's suggestion, and have a couple of more, I think Attorney Rowe's going to be a judge, and maybe one of the other judges on the panel are also going to be a judge. We can see what thoughts were there.
I don't want to, if Judge Faceto wants to say anything, she obviously should join us. There she is. Good to
Yeah,
see you.
good afternoon. I really don't have anything further to add. I agree with Attorneys Yuri and Rowe on the issue. Nothing further.
Okay, why don't we do this? I think I heard that Judge Armada and Judge McLaughlin went to, I think those are the two names. Judge McLaughlin is not here, and rather than have Judge Armada regale us at this point in time with his experience, I'd want to hear from Judge McLaughlin anyway. And our next meeting is on March 25th. If the mock trial is on March 8th, why don't we do it that way? Why don't we table it now, see if anybody else can attend the March 8th event, and then we can take this back up on March 25th when we'll hopefully have everybody at the table. I don't think, from talking with Attorney Weiner, I don't think this is time sensitive necessarily. So if it has to roll over into the next court year for our consideration, I'd rather have more information than less. Does anybody object to that proposal to move forward? Okay, thank you very much for everybody who's joined us on this item.
Thank you, Irvin.
The next item is 2023-008, proposal to amend various practice book sections regarding the pathways process and family matters. Let me get myself organized here. Where to go? Okay. We just got today a substantive response to Judge, oh, there he is, Judge Diana. Good to see you. I don't know.
Justice McDonald.
So let me make sure we're all on the same page. You had forwarded a proposed modified rule really relating to 25-50, I believe, correct?
Yeah, 2534 and 2550. Yeah.
Right. And just this morning, I don't even know if you've seen it. We received some written correspondence from Attorney Podolsky with ongoing concerns with some of the drafts. Have you even seen that?
I did see legal services, but I received that on Friday about after 5 o'clock. I received something from the CBA and the American Association of Matrimonial Lawyers this morning.
I don't think I've received that.
Did you see that?
Let me see. Attorney Podolsky, are you on the call? I think I saw you earlier.
Yes, I'm here,
There
and I
you
think Attorney Diaz is also here from Legal Services.
Okay, Attorney Diaz, please engage your camera as well. Could somebody, I just want to make sure that everybody's on the same page of what information people have, because I think there's additional information that members of the committee don't even have from the academy. But why don't I ask Attorney Podolsky that what you emailed to the committee this morning, is that what Judge Diana got on Friday?
It's the same thing. It's my fault. I should have gone out at the same time. But Attorney Diaz mailed it to Judge Diana on Friday. And I want to apologize for all of us that we were. I wish this were moving quicker, and part of that is our own internal slowdowns and getting feedback to Judge Diana. But so I realize that there are people who would not otherwise have received it, and then I have not seen what came from the Bar Association as yet. So, but I know the family law section has a lot of concerns.
Okay, let me say I appreciate your representation, but this is not directed just at this item. We are getting a lot of late information being sent to the members of the committee when we're trying to do this work and our other responsibilities and our day jobs. So please, anybody who's listening, if you have an item before us, try to get your responses to Attorney Del Campo's entreaties at least a week before the meeting, so that we don't have these kinds of problems in the future. So having said that, let me ask in the abstract, because I have not had a chance to look at what you sent this morning, Attorney Podolsky, in any detail. I haven't seen anything from the academy. Is this kind of writ large? Are we ever going to hope for any kind of agreement, or the committee is just gonna have to pick and choose and paw our way through the two proposals to figure out a solution here?
I don't know if that's questions addressed to me or to Judge Diana or someone else. I can try and answer from our perspective.
Well, you're talking first, so why don't you?
Well, okay. Now, I mean, I think there's room for agreement. I mean, I think that in some broad sense, there's a recognition that Pathways is the system being used. The particular kinds of things, I think I continue to think there's a middle ground on. It's got to do with the scheduling more than anything else for us. Maybe a little different from some of the other attorneys, but it has to do with how you go about scheduling things that are really important, that there be a court order in place, and to what extent that referring something to what's essentially a negotiating meeting can substitute if it's not also going to lead to an order on the same day. And trying to figure out how to do that and decide, for example, what is sufficiently urgent that it might fall into a special category. I think there's room, my hope at least is there's room to work those things out, but I don't think they have in fact been worked out yet. We had taken a shot at that. Judge Diana's response indicated that it wasn't really satisfactory. What we were trying to do, and what came, and I understand came very late to you, was an effort to take into consideration Judge Diana's response, but to still try to explore where we still thought it was really important. And I think, and I do hope that you again, we have a particular area because we're representing low-income clients, but my understanding is the Bar Association, the Family Law Section, which has a much broader range of clients, has very similar concerns, and I don't know where they have come down exactly, but I don't think we're at impasse. If that's the ultimate question, are we at impasse? I think the answer is no.
That is the ultimate question. I appreciate your slice of this equation. You've mentioned the bar, and that's obviously an important stakeholder in this as well. I think Judge Diana is approaching this from a totality of the circumstances analysis, if you will, because he's also overseeing a system that has a huge number of unrepresented parties as well. So there are a lot of cross currents, I guess is the best way to characterize it. But let me hear from Judge Diana.
Thank you. I did receive the responses. I think the fundamental difference of opinion is whether things that are filed trigger an automatic date or the court has discretion in setting the next date. Certain hearing dates are out there, the motion docket, case dates. But what we, and I don't think it's an impasse, and I would be happy to meet with legal services again and respond to the Bar Association and the matrimonial lawyers. But that's really the crux of it. It's when are things going to be scheduled? How long can they be scheduled for? And what criteria should a judge look at to make some of these decisions? The model is flexible and it treats cases differently because they're all different. And some of the things that are being proposed to me treats everything the same. And that's really the difference in kind of moving forward. But, you know, I'm very happy to meet again with them to try to discuss it. And also some of the issues, you know, in scheduling, because things can be done this way remotely and live, and lawyers are practicing all over the state, there's a lot of conflicts in when things get scheduled by the court. And we have to take care and to make sure that the 6 judges here in Hartford and the 40 judges throughout the state have a full docket. And that's hard to do when people are wanting to move things at the last minute. I mean, just like your meeting today. You have an agenda, you want to do certain things, you have a plan, and then some things change at the last minute. Now, but these are not, this has to be resolved. And I'd like it to be resolved, at least with more things resolved than we have today. And then if there still are some things that are unresolved, it would be up to your good committee to just make the decision.
Totally agree with that. I'll call on Judge Stewart next. Let me just be very clear, though, to everybody who's been working on this, we're not going back. We are moving forward in one fashion or another. And so, you know, the lack of having promulgated rules presents its own problem to the family division, to litigants, to attorneys, not having it clearly articulated and in a way that people have ready access to the information and rules that are going to govern the procedure of their case. So we need to come to a conclusion. One of the reasons I don't want to move forward today is because I haven't reviewed what was sent to us this morning. Apparently there's even more information, but I'm telling you, I need and I know I'm not saying you haven't, I need everybody to get into the room and come up with the best solution you have. And to Judge Diana's point, if you have ultimate disagreements, I want those disagreements to be clearly redlined, if you will, so we have exactly, we know exactly what this committee is going to have to do to resolve the disputes that are between and among the stakeholders. We've been very patient with everybody. We need to move forward. We need to get this done. And I've talked long enough. Judge Stewart.
I have a comment and then a motion, but the comment is simply less is more. I did look at all of this stuff very carefully throughout my lunch hour today. I don't have the two most recent submissions. I do have Attorney Podolsky's submission, and I just feel like at this point, what's being argued is way too much micro detail. So that's my comment. My motion is for the committee to approve two other little rules that were altered at my request at a previous meeting, and those are 2517 and 2523. I'm searching around. They are in lowercase I, and they're very short, but I'm just concerned with all the, I hate to call it controversy, but over 2534 and 2550 that they'll get lost in the shuffle. Those rules were changed slightly because I pointed out that they're kind of they had titles and so on from the old regime. And so at one point here, we were going to have 3 rules with the title short calendar or something. In any event, Judge Diana changed those. My understanding is they are not controversial, but I didn't want them to fall through the cracks. So I would move that the committee approve the changes that are in submission ID I for 2517, date of hearing, and 2523, motions, requests, and orders of notice.
And they're not interconnected, right? As in my recollection to what is being discussed on 34 and 50. Okay.
Not insofar as the only interconnection is that the old names of them and references to them were not going to be accurate anymore as a result of the anticipated changes. But no, they're not interconnected.
I have to confess, I thought we actually approved those changes last month.
We did approve a slew of other things, but these just got changed in between the last time we had a substantive discussion about this, and it was at my request, and we haven't discussed them at all.
Okay. All right. So that's the motion. Is there a second? Seconded by Judge Green. Is there any discussion from members of the committee or any input from Judge Diana on that motion? If not, all in favor, please raise your hand. Opposed? That passes unanimously. Now, with respect to the larger issue, the elephant that still is lingering in the room, is there, one of the other reasons I don't feel comfortable doing anything today, notwithstanding the fact that we still don't have all of the information, is that a third of this committee is not here today, and there's been a lot of people who have put in a lot of time. So we're going to table this for one more month. I would encourage, and let me first say, I appreciate all of the time people have already put into it. I know it has been a big pressure on everybody who's been doing it. And so you have my gratitude, and I think the gratitude of the committee. I'm not going to ease up on you yet, though. I'm going to ask you to continue your good work, and hopefully we can have some at least modicum of movement before our March meeting, with information provided to the committee at least 1 week in advance of the meeting, so that we can have it, and then we can figure out how we're going to move forward at that point in time. Is there any objection from members of the committee to proceeding in that way? Okay. All right. Again, thank you everybody who's been working on this, and specifically Judge Diana, who came in the middle of this soap opera and has written some of the scripts very nicely for us. So I appreciate it. Okay.
Thank you.
The next item then on our agenda is 2023-016. A proposal to amend the practice book to require all attorneys and self-represented parties subject to e-filing requirements to accept service of documents electronically. I saw Attorney Del Campo. I know we got a proposal from Judge Bellis that I think she coordinated with maybe it was with Judge Diana. Am I mixing up issues?
No, well, this was on the meeting, this was on the committee's agenda last in January. But it was originally submitted by Attorney Lattarulo. All the different CAJs commented on it. You had at the January meeting asked me to coordinate with Judge Bellis some language, because there was never any language given to the committee. I think there was consensus to review language, but you needed that language. So I did confer with Judge Bellis, and she has submitted that proposal that's in your package today, which basically
that's item 16G with the proposed language, just so everybody has it.
Correct.
Okay. Is there, I don't think this is controversial. Is there a motion to approve the language as submitted by Judge Bellis?
So moved.
Is there a second?
Second.
It's been moved and seconded. Is there any discussion on this item? If not, all in favor, please raise your hand. That passes unanimously. Then the next item is 2023-19, a proposal to amend practice book section 30A-5. And I am just, with my lack of real expertise in this area, I'm going to hand this over to Judge Wynne O'Dowd to tell us where we are on this issue.
Sure. I just want to, first of all, thank the committee for giving me an extra month. This was, I think, one of 4 that was presented in January, and 3 were approved by the committee. Attorneys Cimino and Attorney Duva from the State's Attorney's Office and the Public Defender's Office and I were able to meet in that month to discuss what their concerns were. I provided the committee with a revised proposal just to tighten up the language, and that has been circulated to Attorneys Duva and Cimino, who are here today. And my understanding is that there is an agreement with regards to that revised proposed language, which is, I think, D in the packet. And they're here today. I believe I saw them logging on, so they can certainly put their position on the record, but that's my understanding.
I appreciate that. Yeah, we are talking about item 19D has the proposed language, and at least as of Friday, you had not heard back from Attorney Cimino, who's joining us now, so I'll let her speak for herself.
Thank you. Thank you for giving us an opportunity. We were able to work it out. I did see the additional changes that you made, Judge Wynne, and I am in agreement with them. I apologize for not getting back to you sooner.
All right,
That's right.
and
Thank you.
Attorney Duva?
Yes, everything is accurate, and I think the language is fine now. Thank you.
See, we can reach consensus on items. All right, with gratitude, I will accept a motion to approve the language as written in item 19D that has been submitted to the committee. Is there a motion to approve?
So moved.
Is there a second?
I'll second.
Seconded. Is there any discussion? If
Your
not,
Honor, may I comment,
yes,
Your Honor?
you can.
We suggest, in reviewing it, we suggested, maybe in the, let's see, I'm sorry, I will get this. That in the new language in subsection C talks about the judicial authority, reviewed by the judicial authority and a finding that such placement is, or the level of risk. We suggest that finding there be followed by a finding, and a finding has been made by the judicial authority. So it would say that the reviewed by the judicial authority and a finding has been made by the judicial authority. That seems to be missing some verb there.
Who's doing the finding? Yeah. Okay.
Right.
I hear what you're saying. That seems to be a friendly amendment. Is there any concern from Judge Wynn O'Dowd or Attorney Semino or Duva?
No.
Okay.
No,
So
you're-
with that friendly amendment, then I will ask for a vote. All in favor, please raise your hand. Opposed? That passes unanimously. And thank you for protecting us from ourselves, Attorney Del Campo. You and your staff do that amiably. So then, admirably, I should say, and amiably. So then the next item is 2023-23, proposal to adopt a new rule which require the state to provide detailed pretrial notice of an intent to present prior uncharged sexual misconduct. I know we have Attorney Lawler with us. I don't know if Attorney Fisher is on the call. I see her initials, and now I see her countenance. So good to see both of you. I understand that we have received, again, somewhat late, slightly differing proposals from the Office of the Chief State's Attorney. And Attorney Fisher, I don't know if your comments are on your own behalf or if they are offered in conjunction with the Office of the Chief Public Defender. Could you just clarify that for me?
Certainly, they are in conjunction with the Office of Chief Public Defender and also the CCDLA. And I all conferred and agreed on one particular draft, which I think I have now sent on to the committee.
Okay, and I have not, we received that late as well. So I have not had I had a very busy morning. I'm sure others did too. I've not had a chance to review that. But quickly looking at it, it didn't look like there was a huge amount of sunlight between the two proposals. And so I guess I'd ask for representations from Attorney Fisher and Attorney Lawler, whether you think this is a bridge that can be crossed with some further discussion between the stakeholders.
Yes, I would like to address that. Thank you, Your Honor. And again, thank you to the committee for giving me the opportunity to speak. Attorney Lawler had sent over a draft. We sent a draft over to him, we meaning the Office of Chief Public Defender, CCDLA, and I. And the two, and didn't realize that they were both going to be able to get to the committee this morning. So I apologize for the late submission. As the committee will see when you review the two drafts, they are quite similar, and I think there's going to be a good opportunity to have a consensus on it. There are a few points of differences, one being the number of days before trial or pretrial, another being the defense bar. People on this side of the aisle would like all witness statements to be provided, and also if there is a late disclosure that, like in the federal rule, committee notes that the court, if a finding of good cause for late disclosure is made, that the court could implement protective measures in case there's any kind of surprise. I think, and the biggest point of difference, I believe, at this point between the two versions is that on this side of the aisle, we're proposing that there be an offer of proof made at court outside the presence of the jury with respect to the proposed witness. And then if there is a discrepancy or a variance between the notice of disclosure and the testimony given at the in the offer of proof, that if the court decides it's immaterial, then that's fine and it can go forward. But the court would need to make that decision as to whether it's material or not. I think the state has a slightly different way of wording that and with a different presumption perhaps built in. But I think those, I believe, are really the key points of difference. They're not many. And I can turn it over to Attorney Lawler. He might have a different take, but I think that's where we are.
Thank you, Attorney Lawler.
Yes, thank you for the opportunity to discuss this with the committee. I agree that, it doesn't seem like there's a ton of daylight between the two. I think it's just more a question of emphasis. Our folks here, they're emphasizing, the kind of in a nutshell, what Samuel Yu was driving at for as opposed to notice as opposed to disclosure. So I think that ours is more emphasized on the notice provisions, whereas the public defenders and Attorney Fisher are focused more on the disclosure aspects. So I mean, we can continue to further discuss that, but I think that that's also where the committee wants to go with it as well. Which way you'd like?
Is it unrealistic to think that that you could get together and try and resolve this and get language to us about a week before our meeting in March?
I'm an eternal optimist. I would think that we would be able to do that and certainly be able to get it to you. I apologize for it coming in today. It's just we had just gotten theirs and we tried to just get it in today.
No worries. Did anybody on the committee want to address this item before we send these fine folks on their way to collaborate extensively or additionally? Okay, so we will table that until our next meeting in March. And I appreciate everything. Attorney Fisher?
But I just want to make sure I understand the timing that you would like. Are you looking for us between the Attorney Lawler and myself to get a draft, hopefully, and if not two drafts, to the committee a week before the next meeting? Okay.
Yes, but now that you say that, I was running too fast. At some point in time, before you send it to us, I would hope that you'd both reach out and bring in Judge Gold on it so that he's not caught unaware, so he understands what the proposal is before our meeting in March.
Okay, will do.
Okay.
Thank you, Your Honor.
We'll get it as close as we can and then I'll bring it to Judge Gold.
All right, thank you.
Thank you.
Thank you very much, guys.
Yeah.
Okay, the next item then is 2023-24, a proposal to amend practice book section 2-85 concerning the bar application fee. And Attorney Del Campo, I believe this was a proposal sent to us by Robert Barrio, if I'm pronouncing it correctly. And
yes,
we have Attorney Harrington with us. I don't know if Mr. Barrio is on the call, but we did get a written response from him about the reasons he's proposing this. I don't know if Attorney Harrington has had a chance to review that and is prepared to address it, but I'll turn the floor over to her at this point.
Thank you, Your Honor. This is Kathy Harrington, Deputy Director of Attorney Services. We did receive the material on Thursday. While we've had an opportunity to look at it, I have not had an opportunity to submit it to the committee to get an official response to each of the items that he lists, but I can go through and highlight some quick responses for the committee if you like.
Just briefly, please.
Thank you. So for the first point where it's indicated that both Massachusetts and Texas offer these waivers, I would note that Massachusetts is a vastly different filing system. The bar application is actually filed as a court filing, and that is why, just as with their other filings that an individual may request an indigency waiver, they're not self-funded as our committee is funded. As you may or may not know, all of the fees that we take in pay the salaries and the benefits of staff. It also pays for the bar exam materials. It pays for the bar exam sites, both the main site and the non-standard testing site, proctors, graders, and so forth. Outside vendors, for example, we're building an online portal and we have been using that, paying a separate vendor for that. I'm not certain what their system is, but I would think that it would probably be similar. I can tell you I have a fairly recent listserv information. It's not all of the jurisdictions have responded, but the information I have is roughly 45 to 46 jurisdictions do not offer this type of waiver. So as you can see, Connecticut really stands with the vast majority of other jurisdictions. I do think it's important that to point out that his statement that we would not lose money is conclusory. It's an assumption, and it's actually not true. Because if we don't bring in the fees, we actually will lose money because, as I indicated, we are expending expenses every exam cycle for all of the items that I mentioned to you. There's even more. For example, the credit reports we run, we pay our vendors, the background checks, we pay the vendor. So we actually would lose money if applicants were allowed to have the fee waived.
Can I ask let me
Yes,
ask a silly question. What is the fee? I don't even know.
Sure. So the bar application fee is $800 if you file within the first month. If you wait and file the second month, it's $900. I would mention that there's a UBE fee. That's to transfer. The fee is $750, and that's relevant based on his reluctance to sit in Massachusetts. If he was to sit in Massachusetts and get a fee waiver, if he was to score high enough, he could transfer it to us for $750, which is less than the bar application fee. But we have no reason. I'm sorry, Your Honor.
No, I'm just also trying to figure out what the I don't know if you have an answer to this, but what the magnitude of the problem is. Do we have any understanding of how many individuals would be filing as indigent?
Your Honor, well, one, we have no reason to believe that people who are indigent actually don't file for the exam. For example, and this is public information, that the person who filed this has actually applied more than 5 times in our state. So the letter gives the impression that they've never filed or didn't file, or that people would never file, and that's actually not the case. Secondly, most of our bar applicants, as when they come out of law school, I mean, quite frankly, most of them probably could qualify. They come out with significant law school debt. Most of them do not have a current full-time job, correct? They're studying for the bar exam that summer. Some may have job commitments for the fall, but they may not. If on paper, they might qualify for a waiver. If that's something that the Rules Committee wants to look at, it would have to be a significant change to the funding of the Bar Examining Committee, because most of the applicants then would qualify and we would have no fees coming in. And like I indicated, we are self-funded. We reimburse the judicial branch for salaries and benefits for staff, in addition to, like I said, the site, proctors, graders, and so forth. I don't want to belabor that, but there are significant expenses that we do have. Just quickly.
Just out of curiosity, do you know if there is, I mean, is there anything that, any kind of application or funding source from the Connecticut Bar Foundation or anything like that that somebody could apply to for a hardship?
I'm not certain with the Connecticut Bar Foundation, Your Honor, but I did just do a quick search online. We don't usually do this type of thing for applicants because it's really just not appropriate for us to get involved in this situation. However, I went to Access Lex. They provide a lot of scholarships, especially for first-time law school attendees and their families. But I did a quick search for Bar Study on their website. It's public information, Bar Study scholarships, and there's 54 that are listed there. Now, some of them are very specific. For example, you have to be, sitting for the Florida bar exam, or you have to be a woman, or whatever the case may be. But there were at least 54 that an individual could go through and look through for a scholarship.
Okay.
And then there are bar loans too.
Anything from members of the committee at this point? Thoughts about how we should proceed, if at all? Judge Pearson.
Yeah. Oh, I don't know if somebody else was starting to talk, Attorney.
I was,
Justice
Your
McDonald.
Honor. Excuse me. I'm sorry. I was just going to say that Mr. Berrio is in attendance. He does have his hand up as well.
Okay. Mr. Berrio, if you want to engage your camera, if you have a camera, that would be appreciated. If not, just engage your audio.
Hello.
Hi. Did you want to say anything briefly to the committee?
I do apologize for being late to the meeting at a doctor's appointment that I just got out of. I do apologize also. I wasn't really here for the first part of the president of the Bar Examining Committee's argument. I only heard the last half, and so I did just want to say that I'm sure everyone received the letter that I wrote. I don't want to rehash what I argued for in the letter, because I'm sure you guys read it, but pretty much what I'm just to summarize everything. I personally speaking, I would like to sit for the bar. I can't afford it. I know that there are other jurisdictions that do have fee waivers for persons who are unable to afford the $900 fee to take the bar, or whatever it is in other jurisdictions. I think it's the same in Massachusetts, $900, and other jurisdictions have similar high fees, which $900 is a lot of money. And I am very sympathetic to the arguments that have been made that bar application fees are really the primary source of revenue for the Bar Examining Committee. I certainly don't want to do anything to jeopardize the funding that the Bar Examining Committee receives, whether it be from bar exam fees or other sources of revenue. But I think that whether it be through amending the rules or working with the Connecticut Bar Association to come up with a hardship loan or a grant or a scholarship to help people like myself. That's another good idea that I think she brought up as well. But that's really all that I have to say at the moment. I don't know if anyone has any questions for me. I do apologize again for being late to the meeting.
Don't worry about it. I don't think we have any questions, but I want to be very clear that I don't think anybody is unsympathetic to the issue that you are raising. So I don't know that we have a solution for you right now, but I don't think anybody is. I will phrase it differently. I'm very happy that you brought this to us. I don't know that we have a solution for you, but I'm happy you brought it to us. One of the things that I mentioned, and you might, I would ask you to take on some additional homework if you don't mind, is to find out whether the Connecticut Bar Foundation has any kind of resources that could be brought to bear for people who are indigent. But more broadly, I guess if I could ask you to do the legwork of finding out what it means in the jurisdictions you've identified in Massachusetts and Texas, what it means to be indigent, what are their criteria, and frankly, what is the volume of people who are applying for those types of things. So because we don't right now know how big the problem is, and Attorney Harrington makes the point that there are an awful lot of people who are coming out of law school that without the grace of family or friends would probably qualify as indigent with all of their student, or even bankrupt with all of their student loans and no income. So we're trying to get our hands wrapped around the magnitude of the issue before we can even think about potential solutions, if there are any available.
Yeah, absolutely. I will reach out. Oops. Oh, I will reach out to those two jurisdictions and get the answers. And I will also reach out. Is it the Connecticut Bar Association, or is the Connecticut Bar Foundation a different entity from that?
Yeah, they're different entities. You may want to. I don't want to speak for them. They may have nothing to offer, but it's certainly worth an inquiry.
Okay, yes, I will reach out to both of those organizations as well. And I will write a letter and submit it in about 3 weeks, if that's okay.
That's fine. And I think I could also speak for Attorney Harrington. She's also very concerned about the subject. She has an operation she has to hold together because they're not exactly well funded, and if they don't have the revenue, they're not going to be able to perform their services. So it's got to come from somewhere. But okay, so we'll put this on hold. We'll table this. And if you could get back to us in 2 or 3 weeks, that would be great.
Thank you, Your Honor.
Thank you. And I appreciate your time. And Attorney Harrington, thank you for your time as well.
Thank you kindly.
Okay, the next item is 2024-001, a proposal regarding the principles of professionalism. And I did see Attorney Sullivan earlier. I don't know if he's still with us, but there's Attorney Slack. I know that we got a response from Attorney Slack, basically saying, good stuff, not our jurisdiction, if I can summarize it. So, is Attorney Sullivan on?
Yes, Your Honor.
Okay. If you want to engage your camera, that'd be great.
Oh.
So I don't know if you saw the response that we got from Attorney Slack, but basically the Office of the Chief Disciplinary Counsel and the Statewide Bar Council is saying they, in essence, they have a mandate to enforce rules that have legal consequences, and the principles that you've shared with the committee are aspirational, professional ones that don't apply to. I mean, mostly apply to. Well, in some instances, only apply to litigators, not necessarily a corporate attorney or general practice of law in the state. And so he's suggesting that if there's anything to be considered here, it would be potentially incorporating some or all of the principles in the preamble to the practice book. And I don't know if you had heard that or have any response to that suggestion.
No, I think that the proposal is to have incorporated into the preamble. And on the issue of whether or not this is limited to litigators, the practice book itself is primarily addressed to litigation. And so I think it would be fitting to have this as the preamble. I would also submit that some of the principles apply neutrally to other areas of the law, like being honest and being truthful. That would apply to real estate transactions and wills and trusts and estates.
So, and I misspoke. I said the practice book. He was suggesting it to be the preamble to the rules of professional conduct. So our last meeting for the court year is next month. I can tell you that I don't anticipate this committee doing anything formally on this subject before next month, unless anybody on the committee wants to contradict my view on the probability of moving this forward. So if that's the case, I would suggest that that the proposal that you sent us was that as it was adopted by the House of Delegates, probably as a matter for the bar in general. I guess I'd ask that if you don't mind, you go back to the CBA and understanding that if anything is going to happen, it would likely be something that would be incorporated into the preamble to the rules of professional conduct, and view this material that you sent to us through that prism, right? We wouldn't, this would not be the language that would be incorporated directly into a preamble. This seemed like it was a little bit broader, a little bit more all-encompassing, and not necessarily capturing the essence of what you're trying to say in terms of the rules of professionalism in a way that would be more appropriate to be included in a preamble to the rules of professional conduct, if I made myself clear.
Sure. It was my understanding that you also wanted the input of different sections of the CBA, and I don't know if you've received anything yet from the other committees.
Attorney Del Campo, I don't think we have we?
No, we have not. Attorney Biggs is on this call, I believe, though, who may be able to shed some light on that.
Well, I mean, I don't, if I'm asking you to go back to the CBA, that would include their sections. And
Sure.
so maybe you could take that offline and try to work with different sections and get us something before the beginning of our next court year over the summer at some point.
That's fine.
I'm
Be
so
happy to
sorry.
do that.
Nothing goes as easily or quickly as you want sometimes, but I do appreciate you sharing this information with us. And I did recognize the initials of the person who drafted it in the code on the last page.
Okay.
Came from my old law firm. I still recognize the coding. Okay. If there's no objection to that, then we will table that until hopefully our September meeting. Thank you very much, Attorney Sullivan. Thank you very much, Attorney Slack. The next item is 2024-002, proposal to amend various practice book rules in accordance with the Connecticut Parentage Act. Attorney Del Campo.
Yes, Your Honor, this is a new item. This is the first time being considered. These are multiple rules that have been amended based on the Parentage Act. I believe Judge Wen O'Dowd is still at the meeting for the presentation.
So let me first say, Judge Wen O'Dowd, if I mess up like this in the future, please correct me. If you or any judge is on for multiple items, please bring it to my attention. I would have taken this up immediately after your last item, so you could have gotten on with your day. I apologize for that. It was not intentional.
Thank you. I appreciate that.
So the proposal, as I saw it, is basically the amalgam of the effort between yourself, the Office of the Attorney General, the Office of the Chief State's Attorney, and the Office of the Chief Public Defender, basically incorporating this language in the applicable practice book sections to bring it into conformity with the legislation. Is that a fair summary?
Yes, and there's also sections within the family practice book sections that the Connecticut Parentage Act would also amend. I don't think Judge Diana is here anymore because we submitted this as a joint proposal. We included all the sections. So it was a monumental task. We went through all of the sections in the family court and the juvenile sections, including the delinquency and child protection sections to make sure that they were in conformity with the Connecticut Parentage Act. I can speak for the sections that affect the juvenile court on the delinquency side and child protection side, that we had multiple meetings, and I want to thank the Attorney General's office, State's Attorney's office, the Public Defender's office, who all have a representative here. This draft that was provided to the committee, at least with the stakeholders that I just mentioned, my understanding is that's by consensus. I'll let Judge Diana speak as to the provisions that affect the family sections, but the juvenile sections, we had multiple meetings and we had multiple drafts. So this is what we came up with and agreed upon, at least as of the submission on February 5th to the committee.
Thank you. Is Judge Diana still on the call in the meeting? Okay. How would members of the committee like to proceed? It seems, I mean, if people want more time to look at it, we can obviously do that. I would hope that we could finalize it by our meeting in March, so it could go forward at the annual meeting this year. I can't say I did this with a fine tooth comb, but it all looked like a lot of work went into finding the right places to make the amendments. I didn't see anything that, notwithstanding all that work, that was earth shattering in terms of substance. So I don't know how members of the committee feel. I'm prepared to move forward if you are. Any thoughts?
Justice McDonald, can I just make one additional comment?
Sure.
So the practice book sections that are proposed here that are before the committee, I didn't incorporate any of the language in the sections that we approved on the delinquency ones, the 4 that we approved, or the 3 that we approved the last meeting, and the 1 that was approved this meeting, 30A-5, because I just didn't want to have all these different proposals. So I didn't merge those 2 sections, but the delinquency sections, the only changes that would be required based on what's presented here is that in any section where child is noted, that it would be child or youth to be in conformity with the general statutes.
You know what? Let me back up and take back what I said. I want to make sure that Attorney Del Campo and his staff have had enough time to review this as well. They oftentimes protect us from ourselves, and I should have inquired about whether or not they've reviewed this first.
We have reviewed it from the legal services point of view, Your Honor. We did assign one of our attorneys here to work with Her Honor and Andre Tarutin, and he did go through this, so I'm comfortable with that. The piecing together of the other rules, I'm not exactly clear on, but those we can I'm sure mesh in if the committee makes a change. I mean, we can look at that. We can make a presentation for the next meeting if you move on these.
Why don't we do that? I mean, there's nothing substantive that is going to, there's no prejudice at all. If we do it this meeting or our next meeting, it would still be all subject to our public hearing in May. So rather than rush it, why don't we table this until the next meeting? That'll give the stakeholders and Judge Wynn O'Dowd and Attorney Del Campo to just get on a tighter messaging to make sure we've got this all right. Does anybody have an objection to that? Understanding I will ask for a vote next month on this. Okay, we will table this item then to our meeting next month. I appreciate everybody's work on this. So then the next item is 2024-003, the proposal to amend practice book section 3-10B relating to remote hearings in civil and family matters. This is the first time we have this on our agenda. We got a letter from Judge Bellis with a proposal to modify rules 3-10. Attorney Del Campo, anything to add?
No, Your Honor. I know that Judge Bellis was invited. She's on trial, so she wasn't able to attend. I did go through this. I did add a cleaner version of this with the commentary so that you would all see it. I just noted in that we did add underlining under that term or remotely. You might have seen in the original draft that wasn't underlined. I just wanted you to recognize that that's new language as well, and you'll see it by double underlines in my draft. So if you're going to vote on this, it's the one that I submitted that you should vote on.
Okay, so what we're really focused on is item 24-3B. It looked pretty straightforward to me. Does anybody have if anybody has a contrary view, we can delay this, but otherwise I would ask for a motion to approve it. Moved by Judge Chaplin, seconded by Judge Stewart.
Actually, I'm not seconding it.
Oh, you weren't seconding. Sorry.
I have a comment as well.
Yeah,
Oh, okay.
this comes up all of the time in front of me, and almost every motion to withdraw ends up having to be scheduled 2 or 3 times because people just can't grasp the concept that what they do is they send the notice out when they file the motion in the first place, and then it gets scheduled, and then right before the hearing, a link gets sent out, like literally the Friday afternoon before the Monday. And this is a great step in the right direction, but I just looked at it during lunch hour, and I'd like to just step back and I know I'll have some of these next Monday and they will be screwed up. And I'd like to just think about it for a week or two before I'm prepared to vote on it. The concept is great. I just want to prevent as many of these reschedulings as possible. That's my perspective.
Okay, Judge Chaplin. Anything?
So I echo those same sentiments that happens both to me in both when I sat in juvenile and the civil, but also run into the same issue sometimes in criminal when we have remote hearings in criminal. And I know that wasn't a proposal, but it's something I think that's worth looking into if we're going to take the step, then maybe considering criminal should be also a part of that consideration. So we can have one rule that addresses all or as many areas as possible rather than piecemealing this process, as this is our new and existing reality.
Judge Pearson, were you trying to say something?
Yes, I have one little nitpick on it, which is the way I read the proposed rule, the idea is to make sure that the self-represented party understands that if the hearing is going to be in person, they need to be in person. If it's going to be remote, they need to know that it's going to be remote and then be provided with the link necessary for them to participate. My concern is that when you get to subsection 3 of B, it says the party may appear in court or remotely on that date and address the court concerning the motion. To me, that if you read that plain language, somebody may say, hey, even if it's an in-person proceeding, I can appear remotely because it says the party may appear in court or remotely on that date. And in the civil, I don't know how it may work in family or other context, but I can tell you in most civil courtrooms, we do not have the ability to conduct hybrid proceedings. You cannot have one person participating remotely and one person doing it in person, another party doing it in person. So it has to be all one or all the other. And I think that subsection 3 could be confusing to a self-rep and lead them to believe they could attend remotely what has been scheduled as an in-person hearing.
Okay, well, that proves the accuracy of Judge Stewart's statement that we need to step back for a second. Why don't I ask anybody who has concerns to, why don't we funnel them through Judge Bellis so that she can give us any proposed changes in the next couple of weeks. And then Judge Chaplin, with respect to your issue on the criminal side, could I ask you to reach out to Judge Gould on that and see if he wants to be part of this effort?
Sure thing.
Okay. Anything else then before we table it until next month? All right, thank you very much. The next item then is 2024-LSS. This is the recommendation for LSSC member reappointments. For members of the committee who aren't familiar with this, I'd ask Attorney Del Campo to give us a brief synopsis of the specialty appointments.
Yes, Your Honor. The practice book allows requires the Chief Justice to, upon recommendation of the Rules Committee, to appoint members of this Legal Specialization Screening Committee. That's the committee that determines whether or not entities can be certified as certifiers of attorneys as specialists in different areas. Attorney Payne is the chair. They have 3-year terms, and Attorney Dwyer is a member. Their terms end this June, and the Chief Justice upon your recommendation, can reappoint them to those 3-year terms. And we have contacted them, or one of the attorneys in legal services has contacted them. They're both willing to serve another 3-year term.
Is there anybody who is opposed to the concept of reappointing these 2 attorneys? Okay, if not, then is there a motion to reappoint both of them?
So moved.
Moved by Judge Chaplin. Is there a second?
Second.
Seconded by Judge Stewart. Any discussion? Seeing no discussion, all in favor, please raise your hands. Opposed? That passes unanimously.
This will go, Your Honor, since excuse me, I'm sorry, this will go as the recommendation to the Chief Justice so that he can reappoint. Okay.
More of a resolution than a motion, I should have said, but yes, it's same concept. Okay, the next item then is 2024-CGA, discussion regarding Rules Committee meeting with the leadership of the Judiciary Committee. So a long time ago in a far off place, the members of the Rules Committee used to meet annually with the leadership, the chair, the co-chairs and the ranking members of the Judiciary Committee. I think it's both called for in the practice book and in a statute. I can't remember the number of the statute. And I reached out to the leadership back in September after we started our court year to see if they wanted to meet then under Rule 1.9A of the practice book. There was not any response received from them at that time. But there's another means. I think it's also under 1.9A subsection B, after the beginning of the legislative session, I'm supposed to invite the Senate and House chairs and the ranking members to discuss anything they want to discuss or we want to discuss with them at a meeting of the Rules Committee. And I sent that to the committee leadership at the beginning of this month. Unlike back in September, we did receive a response indicating that the co-chairs and the ranking members would like to meet with us. I then inquired, actually through Melissa Farley and her good offices, inquired whether they wanted to do so remotely or in person. Word came back that their preference would be to meet in person if possible, rather than doing it remotely. And since this has not happened in several years, it's actually a good way to make sure everybody's on the same page. I would prefer if we could do it in person. So that leads to the question of when can we do it? The most, for us at least, the easiest would be to do it at our next meeting and just have a long day of it, or to schedule a special meeting. I don't know if the leadership of the committee is available on whatever it is, March 25th, 26th, whatever it is. Because I wanted to talk to you folks about it first. And then based on the outcome of this discussion, we will have Melissa Farley try to coordinate a time with the leadership of the committee. So if all the stars were to align, and we could do it at our next regularly scheduled meeting, would folks be available to come to Hartford on March 25th? I'm seeing yeses, so I appreciate the flexibility. People get used to doing things remotely, and so you have to build in travel time oftentimes to get to Hartford. Okay, so if that works, we will check that out. If that works, our meeting in March would be in Hartford in person, and it would combine both our final work for hearing new matters or resolving pending matters, and then having the meeting with the Judiciary Committee. If it doesn't work, and my recollection is that the Judiciary Committee is what's called an A committee, which means that they meet on what Mondays, Wednesdays, and Fridays. So that's either going to be a very good time to meet, or they're going to be swamped and unavailable. So if they are the former, that's great. If they are the latter, we're going to have to ask Joe's staff to start doing a what do they call it? A doodle scheduling. Is that what it's called? The scheduling app to figure out when people are available for a meeting. So let's start and shoot for the stars first to see if we can do it on March 25th. If not, we'll start getting dates from people when we could figure out a time to get everybody together. And that was my update on that subject matter. Anything anybody wants to add on that? Okay. Then if there's anything else we need to do, Attorney Delcampo?
No, Your Honor.
All right. Actually, it's under miscellaneous. I'm going to just throw it out there. Nothing's going to happen, but I would ask members of the committee, if you haven't seen and read a editorial in the Connecticut Law Tribune from February 20th, I would encourage you to do so. It deals with the issue of extensions of time to rule on motions, and a suggestion that there should be some outer parameters of how to deal with situations where there are extensive or excessive extensions. I don't know if it's true, but the assertion is sometimes those delays have taken on more than 5 years. So I don't know what the scope of the problem is, if there is one, but just take a look at it, and we can have a discussion on a going forward basis about whether or not anything should be addressed in the rules. If there's nothing else, then I will, Judge Stewart.
I have one quick thing. As some of you may know, the legislature passed the Interstate Depositions and Discovery Act, making Connecticut, I believe, the 45th state or something like that, to participate in that. And there's some minor chaos among the civil judges right now dealing with situations where people want to take depositions or grab discovery here in Connecticut for their cases in other states, and vice versa. So I have already reached out to Attorney Delcampo to say that I would be happy to work on some draft rules. I've also recruited Judge Pearson to help me because it does look like a number of our rules would be in at least some minor way affected by this. But I just wanted to mention that in case somebody has some incredible interest in the subject matter. But at the moment, our statutes and our practice book are not speaking to one another anymore for some of our mostly depositions, but also document production. So I just bring that up.
I appreciate you taking that initiative, and just touch base with Judge Bellis as you proceed as well.
Oh. You know, she's very, I mean, we did discuss it. The civil judges discussed it in our, I guess it's annual meeting in the fall, and she organized a presentation on it, but it's a moving target. And the family judges, I was recently alerted, and they have this as much as we do. They didn't even know, that the law had changed. So this is what usually with these announcements about these sort of things, but this was sort of stealth in any event. So I think it would be good, in addition to Judge Pearson and me, if there was a family judge involved in our discussions, because they, of course, have many issues where people are in other states trying to get stuff and vice versa.
Judge Armada, did you want, you put your hand up?
I was going to say that we have this on the family side a lot. It's coming. We're seeing more and more of it. I'm happy to work with you and Judge Pearson on this if you need be. But it's the wave of the future.
I will confess I had not heard of it until you just told me about it. So I appreciate you putting it on the radar screen. One final thing about, I forgot to mention about the Judiciary Committee. We should probably try to figure out what issues, if any, we would like to bring up with them. They may have issues that they'd like to address with us, but we should probably have a little agenda of what we're actually going to talk about, so the discussion is focused and productive. So if you have any thoughts, you can call me or email me, and I will take responsibility for coordinating anything that members of the committee want to discuss. And Attorney Del Campo, as I'm thinking about it, would you just please talk to the 3 members of the committee, or email the 3 members of the committee and who are not here today, and let them know about this suggestion about the Judiciary Committee, and just a high-level recap of some of the open-ended issues so that they are not caught unaware for our last meeting in March.
Yes, Your Honor.
All right. Anything else? All right, then I will accept a motion to adjourn.
So moved.
It's been moved by Judge Pearson and seconded by Judge Armada. Any discussion? Seeing none, all in favor, please raise your hand. That passes unanimously with my gratitude. Have a great afternoon, everyone.
Bye.
Bye, everybody.
Hi, everyone.